take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Writer with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Yeah, 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 yeah. Yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the feed. We the California's rolling deep all night. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah, yeah. Junkie, 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 junkie.
Josie, Jamrock, Jamrock.
Junkie, 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 junkie.
Josie, Jamrock, Jamrock.
California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, 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 we stay in the mix. 4 names, 1 flame, can't remix this. Yeah, yeah. Oh, Californians, 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 yes.
Let's go! Oh, let's go! Oh, let's go!
Good morning, good afternoon, good early evening, everyone. How's everybody doing today? Or how was your day, depending on what's going on? Oh boy, so we got day 12. Today we are supposed to hear from the state's rebuttal witnesses in the Josie Dikeman trial and maybe some jury instructions and possibly some closing arguments, at least according to what the judge was saying yesterday. I know yesterday they kind of left off with some housekeeping and probably some legal battle, legalese. So we left about 40 minutes of that off. So that's cool. We won't worry about that. I'm pretty sure the judge will have to revisit it again. So that's that. Considering I didn't ever get anything down packed with this case. Like it seems like they keep rehashing and going over the same stuff that the judge has ruled on. There were points in times where the attorneys were complaining that the judge was allowing another attorney to ask questions that he wasn't allowed to ask. So that's how petty we getting with this one. I don't know. I have to look at the survey. I know we had a premiere this morning. I'm not sure if you guys saw the premiere. Hopefully you did. It was just to kind of catch people up that did not see her testimony or to listen to her testimony once again. Let me see what our survey for that one. I'm interested in to seeing. I can't remember what the final count was. So let me go in there and look. I wondered if people really thought she should testify, because remember, she testified yesterday. And on cross-examination, let me see. I may have to I'll put another one up here because I'm wondering. Oh, yeah, it won't let me see it. Okay, it won't let me see it. I thought it was going to let me see the end results of it before the stream ended this morning, but it won't let me see it. But that's okay. We will do a new poll. I'll put one up today because I want to know, do you guys think she should have testified? I don't know if she should have testified. I mean, I don't think she should have testified if she was going to be getting up there talking about she practiced. Once I heard the word practice come out of her mouth, I was like, oh no, like this is supposed to be you have not practiced, but you have been prepped. She should have never said practice. She should have been like, I was prepped. Practice sounds like you done went through all these answers, and that's why you're so monotone, because you have to be even keel about it. Like, nah, I don't like practice. So I'm putting us a little poll in here in regards to it. I'm gonna go down. Let's do our good mornings. Good morning, Christine. Hey, Esmeralda. Hey, Amy. Good morning, Just Shamrock. Hello, 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 Susie. Hey, Martina. Good morning. Good morning, Lynn. Hey, Only. Hey, Skylar. Good morning. Good morning, everyone. Glad everybody's joining us. Hey, Drunky. Hey, Lynn. I hope I ain't missed nobody. Y'all let me know if I missed somebody. If I missed you, know that I love you even more. Oh, man, guys. So I know that y'all had seen that I had the Folio schedule. I had that schedule first, but then I decided, well, it looks like this one might be our main attraction for today. So let's go ahead and get in here. We will go into Folio today. I haven't figured out what time we are going into Folio. It depends on what I see going on over there, and I'm gonna be honest with you guys. If they get into, I know the state does have some rebuttal witnesses. Like, these trials are neck and neck right now. Okay, both plan to show rebuttal. Both trials, the state is doing rebuttal witnesses. Both trials are going to be going into hopefully closing arguments today. I just know in the Folio trial right now, they're doing jury instructions and blah, blah. Jury's not there. The jury won't be there until a little bit after 10 East Coast time. So I'm like, okay, well, no reason for us to go over there. Let's go ahead and see what Josie has going on. Okay. So without further ado, I'm going to go ahead and take us in the courtroom. Let's see what we have going on today. No.
Computer's being slow.
Matthew Tarbinson and
State versus Josie Dikeman appearance. 23 CF 475 State versus Josie Dikeman appearances.
Matthew Tarbinson and Emily Rood appear for the state. Also present at State's counsel table is Investigative Sergeant Rich Amundsen. Good morning.
Morning, Your Honor. Ms. Dikeman appears in person with her attorneys Chris Acker and David Bowles. Also present is paralegal Emily Sanchez.
So a couple things. What I was doing right now is I was looking at the emails that were sent last night. They were forwarded to me by Ms. Langer. Just so you know, I realized after we were done yesterday, there was two different instructions we had not put in. One was the falsus new. The other one was hypotheticals. We never put the hypothetical one. It's pretty short. I also knew that there was an issue on the falsus new instruction, knowing that's disfavored. I knew that from the instructions, looking at the history of it. There is a lot of contradictory information that's out there for a lot of different witnesses. If I do have it in there right now. We can discuss it more later. I just put it in there just as a at the end of the witness section. I agree with Mr. Torbenson. Generally, it should be neutral. It should be just general. It shouldn't be specific for the children. I know I said something about the children, but I think what I was thinking is that it would be put in there generally. I'll give you an opportunity to respond to that, Mr. Zacher. I'm just wanted to let you know that's where. So I did put those two in. I know that we've done the verdicts, and we've done the redid the whole verdict section at the very end of the jury instructions. So we have that. But we're not actually done, so we can do one more jury instruction conference to go after the details. Plus, I see the additional information for Mr. Pedren for 275. And I don't know if that was just a couple minutes ago. I don't know if you had even a chance to look at it, to be honest.
And I also found amended information. Incorporate the language that we talked about yesterday.
Yeah, let me look to see if has been crossed over yet. Maybe it was. Yeah, and I see there's a, what? It's sitting out there. Okay, we'll cross that over. We'll take a look at that. And the state had said that you will have at least maybe 2 witnesses on rebuttal now?
I believe it'll just be one at this point, Your Honor.
Just one? Okay. Any issues other than what I just talked about, which we'll talk about again after your witness is done?
I don't believe so.
Mr. Zacher?
Beyond what we have to discuss on the falsus and nuno and the amended information.
Okay.
I agree that the hypothetical standard instruction.
Yeah, did you have a problem with the hypothetical? We just didn't mention it last night.
It was done a number of times, so I think it's appropriate.
Okay. All right. Having said that, actually, I don't even know if the jury's up. We have a few minutes before they come in.
Want to take not guilty pleas on the new information, Judge?
Yeah, it's crossed over now. Okay, yeah, why don't we do that? Hold on one second. All it did was change the language, correct?
On count 2, it just.
Yeah.
Yes.
Yeah. Everything's a little slow this morning. Do you have a copy of the information, the amended information?
I got an electronic copy by email this morning.
Okay. Ms. Dikeman, in count 2 now, in the amended information, this might be the second amended information. It charges, same charge, chronic neglect of a child, consequence death, that between January 1st, 2021 and February 11th, 23, that the same time, the only difference is that it changed the language to that says did negligently fail to provide necessary care, necessary food, necessary medical care, necessary education compliance under 118.15, and exposure to drug abuse is defined by 46.973 parent 1, parent D, and then the rest is the same. Do you need me to read more than that?
No, Your Honor, we'll acknowledge receipt of the amended or the Second Amendment information, waive its formal reading. We are specifically objecting, as we did before, to Ms. Dikeman's constitutional right to notice and present the defense. Second subsequent amendment, those objections notwithstanding, Ms. Dikeman will enter a plea not guilty.
Enter not guilty plea to that amended count. The not guilty is already entered in for count 1 and count 3. Also, the court made a decision allowing the state to amend it as of yesterday. So that does remind me, I did modify those instructions on count 2 with the language for 118.15 and 46.973 parent 1, parent B. I just took, there is actually a jury instruction for 118.15. Then I had to take the statutory language for that 46.973 parent 1, parent B. But we'll get you copies of that. I'll have Christina send what current copy we have. Remember, this is still a rough draft. It's not the final draft, but.
Want to hear my response on falsus in uno now, or do you want to do that?
Sure. Why don't we have a little time. We still don't, if you want to talk about falsus in uno, go ahead.
I absolutely agree with the court and Mr. Corbinson that falsus in uno is a disfavored instruction for a number of reasons. I'm in my career, I've ever asked for this, the first time being when I was a law student doing clinicals. I think it's appropriate specifically to at least the one witness to acknowledge that he had been dishonest under oath previously. My problem with making it general is that it, or at least not carving out an exception for the defendant, is that it impacts the presumption of innocence. If the jury's instructed that they can just disregard her testimony entirely at that point. So if we're giving a general instruction, I would just like a caveat added onto there that this doesn't apply to Ms.
I think that's why it's disfavored, actually,
Yeah.
for exactly that reason. And it's one of those questions yeah, I mean, that's why it's disfavored.
My response is actually that it shouldn't be given at all. There's two cases. There's the Wisconsin Supreme Court case, it's State versus Kluge, that is found at 2008 WI 58, and it's discussed at paragraph 71. That case was overturned on other grounds related to another issue, not on that specific issue. And it's State versus Lagar, LAGAR, which is found at 190 West 2nd 423, Wisconsin Court of Appeals decision. Both of those cases discuss at length why the instruction is disfavored, and it's in essence, it's because the credibility instruction tells the jury how they're to weigh credibility with regards to all the witnesses, and certainly a witness giving contradictory information goes to that witness's credibility. My problem with the instruction is a witness can get up and say something that one party may interpret as material, the other party may not interpret as material, and they're going to argue that all of his testimony should be discounted because of that one thing that he said, whereas there may be motives and reasons to explain why he did what he did, and he came in and subsequently corrected that when he testified. So I'm asking the court not to give the instruction. I think the credibility instruction adequately covers all the factors that the jury is to consider with regards to all the witnesses, the defendant, and every single other witness that took the stand in this case.
Your Honor, the problem with that is that we'll be left without a remedy for the situation that we got into with Brantley in particular. So our request is that it, at the very least, be given specific.
The only other thing I'd point out is some of the case law where it discusses it, it's where the prosecution asked for it relative to a defendant's testimony. So that's the other reason why it appears as though the prosecution may be able to ask for it relative to the defendant. I am not in this case. I want the general credibility instruction for Ms. Dikeman, and I want that for every other witness as well.
Yeah, one thing that it says in the logger is that impeachment of a witness with prior statements does not necessarily mean in falsus in uno instructions appropriate. The testimony must be show a willful and intentional disregard of the truth. The trial court has the best position to make the call. We see no error in the court's discretion. It's obviously jury instructions are left to the court's discretion, which is part of why they didn't strike it down on that basis. But what I find interesting, the question is, is it a willful and an intentional lie? I think the argument has been that it's been influenced from the defense, correct?
That the testimony was coached and influenced, yes. But I think all we needed was when he came back on the stand after the break and acknowledged that he had lied under oath. That seems to fit the definition of willful intentional.
Yeah, it's a kid though. This gets more complicated because it's a kid. I think that's where it gets. We're there are a lot of issues with children testifying, and it becomes very complicated because even getting to the truth and the lie, where there was sort of there are hesitations in the original and about if they understood fully what it meant. Of course, with the explanations, red, blue, markers, etc. Those are easy things to say yes and no to. Do you understand the consequences? And there was sort of a blank no response to it at different times. That's all part of closing argument to a degree. About the reliability of those statements. The question is falsus nunu, is that really appropriate given that situation? We're going to have one more meeting. Give me a little more time to think about it. But I understand the state's position. I understand what the case law says. I read the other case before. I hadn't read this case. The question really in my mind is, are you getting to a willful, intentional lie, or is this part of this? The theory of the case is the theory of at least the statement by the child is that it was somehow influenced. Not to mention the ability to essentially manipulate memories. We know that happens with children. There's famous cases over that. Probably one of the most famous from Minnesota. So it becomes one of these issues of, what's the real intent of the child, or is it the manipulation of the child, or the facet of sometimes for children, it's also not even a manipulation. It's just it was testified to that Brantley, for example, has a very active imagination. So I'm not sure. I just thought out loud and said it out loud. And so give me a moment to think about it.
Yeah, sure.
We'll talk
Can
again.
I just add one thing on that last part?
Yeah.
So when he came back and took the stand, I think it's important to note that when he went outside, his father was upset with him, not coaching him. He was upset because he was denying that there was domestic abuse. Back in and said exactly that he had an encounter with his dad. And so the testimony establishes, he also said he was trying to protect his dad. He thought somehow, I think there was questioning by Attorney Zacher, that he believed that if he said something relative to his dad abusing Miss Dikeman, that may cause his dad to get in trouble. That's not an intent to get Miss Dikeman in trouble. That's an intent to protect his dad, which is very different, at least in my mind. I think that all of that can be argued in credibility. I don't think we need the falsus in uno to address it.
The other issue just generally is I don't want it to create the constitutional issue, which is, as you were saying, the constitutional issue, which is all of a sudden, I know this is why you want the specific, language in it, Mr. Zacher, but the reality is that I'm not sure. So it says, okay, in this one witness, it also would highlight this one witness. It's not necessarily, that's not necessarily the purpose of it. I've seen attorneys argue the rotten piece of meat in the stew, you know, analogy many times, you know, do you eat the whole bowl of stew or do you, or do you eat the rest of the stew or do you throw it all out because one piece is rotten? So
I'm more of a sandwich guy, Judge, but
you're
I
the
understand
sandwich
the-
guy, yeah.
Um,
I think
the,
it's a Belzer can of one.
yeah, my, just correcting the record on the point, I believe what the child came back and testified to was that he was lying about his father drinking, not about the violence.
Okay, so this is, I'm gonna hold off a little bit. I'll be frank, I'm leaning towards taking it out right now altogether and just letting you argue it.
Sure.
But let's give it another moment. Plus, we have to work on the language on the 275.
Judge, I just sent our counter proposal on 275. We can talk about that later.
All
Since
right.
I know no one's had time to review it.
Yeah, let's talk about that later. You sent that to Christina, right?
Yes.
All right, so she'll forward it to me eventually. Let me go see what's going on with the jury. Oh, okay, somebody's running late. Why don't we take about a 5-minute break and we'll start once they're all here.
Objection.
Okay, so you're, I heard that. All right. Okay. Everybody's back in the courtroom. The jury is all here now. Can we bring the jury in?
Yes.
Before, one thing, I will say to the jury that defense rests. Now it's an opportunity for rebuttal, just to explain where we're at, and then I'll have you call your witness. Okay, let's bring the jury in. Everybody may be seated. Morning, everyone. We will, at this point, I think when you left yesterday, we had, the defense had rested. At this point, the state has the opportunity for rebuttal. We had to wait a little bit till this morning. What we'll do is we'll start with the state's rebuttal if you want to call your first witness.
Thank you, Your Honor. State calls Investigative Sergeant Rich Amundson.
Do you solemnly swear the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Good morning.
Morning.
Can I have you state and spell your name again for the record?
Richard Amundson, Amundsen.
And Sergeant, I'm going to hand you another stack of documents, and we'll go through them one by one, okay?
Okay.
Sergeant, do you recall during Ms. Dikeman's testimony yesterday that the bag of pills that we've been discussing in this matter may have been placed on or on top of her clothes hanger?
Yes.
And when you were processing the scene, did you have the opportunity to observe the clothes hanger in her bedroom?
Yes.
If I can have you look at Exhibit 154, Sergeant, can you please identify what we're looking at here?
This is a photo from Miss Dikeman's bedroom showing the clothes hanger rack storage shelf.
And from your review of that photo, is it in the same location as it was when you processed the scene on the 11th of February, 2023?
Yes.
Is it a true and accurate representation in that photo?
Yes.
Your Honor, I'd move for the admission of Exhibit 154 and request to publish, please.
Okay.
No objection.
You received? Go ahead. Publish.
Let's switch to my computer, please. Sergeant, can you tell us what we're looking at here?
To orientate yourself, these are the French doors that go into the living room. Miss Dikeman's bed would be right in here. And then in this corner is that clothes rack with hangers here and here, and an area to store things above it.
Thank you. I'm going to have you look now at Exhibit 155. And before we go through this, do you also recall over the last few days there being testimony about the pictures Ms. Dikeman was taking around 9 p.m. on the evening of February 10th?
Yes.
And was there discussion of whether or not Ms. Dikeman had makeup on in those photos or was using a filter or things along those lines?
Yes.
I can have you now look at Exhibit 155. Is this another Cellbrite extraction report from Ms. Dikeman's iPhone extracted on the 13th of February, 2023?
It is.
And is this specific report related to the photos Ms. Dikeman captured between 9 p.m. and approximately 9:30 p.m. on the 10th of February?
Yes.
Given your review of this data, is it a true and accurate reflection of what was on the Cellbrite extraction for Ms. Dikeman's phone?
It is.
Your Honor, I'd move for the admission of Exhibit 155.
No objection.
Received.
Sergeant, does this extraction report identify that there were 41 files contained in this portion of the extraction?
It does.
And from your review of this report and the data, does it appear that the phone is capturing both the full-size image and also a thumbnail image when we're pulling the information in this report?
It does.
So when we're looking at the overall total of photos actually captured, does it appear that there are about 20 photos of Ms. Dikeman captured in this time period?
That is correct.
If we look at entry number 1 in this report, Sergeant, can you please tell us what the capture time is for that first photo?
February 10th, 2023 at 9:02 and 42 seconds p.m.
And then if we look at number 39 on page 10 of this report, what time does it indicate that that selfie or photo was captured?
February 10th, 2023
at 9:20 and 14 seconds PM.
And then if I can have the Elmo, please, I'm going to republish exhibit 254. Sergeant, is this the photo that was testified to as being sent to Mr. Suarez by Ms. Dikeman on the night of the 10th of February?
Yes.
And if we look at entry number 18 on exhibit 155, does it indicate that the file name related to this image is IMG_0549 period HEIC?
Yes.
And what is the capture time of that image?
February 10th, 2023 at 9:16 and 31 seconds PM.
I can have you now turn to exhibit 156 in front of you. Do you recognize this exhibit?
Yes.
Is this one of the selfies captured by Ms. Dikeman during the period of time we're talking about right now?
Yes.
And if you can, while we're identifying this, refer to report 150 or exhibit 155, Sergeant. Does this photo have the file name IMG_0541 period HEIC?
Yes, it does.
And what is the capture time related to that image?
February 10th, 2023 at 9:02 and 42 seconds PM.
And is this information, including the contents of the photo, true and accurate based on your review?
Yes.
Your Honor, I move the admission of 156, not requesting to publish quite yet, though.
No objection.
Received.
If I can have you then turn to exhibit 157, Sergeant. What are we looking at here?
This is another selfie that Ms. Dikeman captured on February 10th of 2023. This time she's wearing glasses and makeup.
And if you refer to exhibit 155, specifically entry 38, does this particular photo have a file name of IMG0559.HEIC?
Yes, it does.
And what's the specific capture time related to that photo?
February 10th, 2023 at 9:19 and 12 seconds PM.
And based on your review of the information, is the content of the photo and that creation data we just discussed true and accurate?
Yes.
Your Honor, I'd also move for the admission of exhibit 157, not requesting to publish quite yet.
Objection.
Received.
Now on to exhibit 158, Sergeant. Can you please explain to us what you're looking at here?
Exhibit 158 is the two photos I just discussed side by side on the same sheet of paper.
And is the information contained, including the content of the pictures and that file name and capture time, true and accurate based on your review?
Yes.
Your Honor, I'd move for the admission of exhibit 158 and request to publish.
Objection.
Received, publish.
Have it switch to the computer, please. Okay, Sergeant. So these are the two photos, 156, which was captured at 9:02 PM, and then 157, which was captured at 9:19 PM, correct?
Correct.
Okay. And what facial features, based on your observation, do you see differently in these two photos?
To start with the one captured at 9:02, you can see how Miss Dikeman's hair isn't brushed out, more stringy. You'll see that there's no eyeliner between the first photo to the second folder. It appears her skin tone is more leveled out. Then she's also got lip gloss on in the second photo compared to the first photo. You can see here that Miss Dikeman's hair has been brushed out. It is on now the left side of her body compared to more on the right side on the first photo.
And that second photo's capture time is 9:19 p.m., correct?
Correct. And the most obvious is obviously she's got glasses on compared to no glasses.
Thank you. And that 9:19 capture time is about 3 minutes different from the capture time of approximately 9:16 that we saw in Exhibit 254, the photo with Ms. Dikeman and Brantley, correct?
Yes.
Thank you. I have nothing further.
Redirect or recross any or cross?
I mean,
Excuse me.
all right. So Sergeant, I want to look at 154 again. My copy of the state's exhibit. It looks like there's a flexible fabric shelf system in that photo. Is that correct?
I'm not sure, but
I have one of these in my closet, so I know what this looks like. Let me zoom in on it. Kind of looks like it's kind of hanging and the shelves are sagging a little bit.
yes.
The only empty shelf on this unit would be the bottom one. I can zoom out if you'd like to see the top.
Yes.
Don't see any hangers that were apparently knocked over from taking a bag off of the top there.
No.
Let's talk about the pictures. Sergeant, would you agree with me that everybody takes pictures that they don't necessarily like or say, I'm going to delete this one of myself?
Sure.
And Ms. Dikeman, in some of those earlier pictures, would you say looked a little bit haggard?
Yes.
Like maybe she hadn't been feeling well?
I don't know how she was feeling.
And the photos that she was sending to Mr. Porfirio were the touched up versions. Is that fair to say?
I don't see anything where a filter was used to touch him up. I think her face was touched up.
Yep, that's what I meant.
Oh, okay. Yes.
Where presumably if Ms. Dikeman's trying to impress her date, she's going to take the picture where she looks good and send it to him.
I would assume so.
And just looking at some of the photos here, I'm going to bring 158 up to you because I'm not sure the glare really.
He has it in front of him.
Oh, sure. Would you agree with me, Sergeant, that some of the same facial blemishes appear on both photos?
Yes.
In other words, she has a cold sore or something above her lip.
I don't think it's a cold sore. It looks like a freckle or something.
Same thing on her cheek there. Looks like there's either a freckle or something else.
Yes.
Okay. I was not a makeup expert until yesterday, but does it look to you that she applied foundation?
I'm not a makeup expert either.
Okay. And just looking at the earlier photo here, Sergeant, the 156. We can actually see that Ms. Dikeman does appear to have eyeliner on, just maybe not applied as consistently. Can you see that?
I can see her bottom eyelashes, but it doesn't appear that there's any eyeliner on there compared to 157.
I'll just walk up to you for 156 here. And again, I'm not sure the glare will capture this on the Elmo, but do you see eyeliner or what appears to be eyeliner on the bottom of Ms. Dikeman's eyelids?
I see black individual eyelashes.
I'm gonna try and publish 156. It's glossy, but we'll. And I'm gonna zoom in on your eyes. Can you see the shade underneath? I guess that would be her right eye.
Yes,
You see the shade under portion of what would be her left eye?
I can see what you're pointing out. Yes.
And does it appear that there is, I knew the word for this yesterday, but the makeup that you put on top of your eye lids?
I don't know.
Mascara?
Your Honor, I'm going to object to this. I don't think he has a frame of reference for what our eyes look like with or without makeup based on this photo.
Yeah, he's saying he doesn't know makeup,
Okay,
so
yeah.
I'll sustain the objection.
It's apparent to you that Ms. Dikeman was trying to make herself look cute to send a picture to Raphael?
Asked and answered, Your Honor.
Yeah, sustain.
All the questions I have.
All right, any redirect?
Very briefly, Your Honor. Investigator, was the testimony we heard from Ms. Dikeman that the bag would have been placed up high out of the reach of children yesterday?
Yes,
And is there a flat surface on top of that clothes hanger?
yes, on top of that clothes hanger, there is a flat surface and there's other items on top of it as well.
Thank you. Nothing further.
Any recross?
Sergeant, do you still agree that there's no way to determine whether or not that bag was actually there on February 10th on top of the shelf?
I do not know that.
Nothing further.
Anything further?
Not on that, Judge. Thank you.
All right, you step down when I handle the exhibits. Any other witnesses from the state?
No, Your Honor. State rests.
Okay. So with that, ladies and gentlemen, that ends the testimony evidence for the trial. We did some work yesterday, so we do need a little time to finish up what we were working on. They're the jury instructions, which I'll be giving to you next, and then we'll be going to closings. What I still ask you to do is please don't talk about the case. I know we're done with the evidence, but until I give you the instructions, I can't have you talk about the case. And then once we do the closings, 2 random numbers will be picked, and 2 of you will be the alternates. I really do appreciate all 14 you made it through all the whole time, but we do need to get down to 12 people at that point. Having said that, we will see you. Every time I predict this, I predict wrong, but it will at least be about half an hour to 45 minutes. It could be a little bit longer. Okay, thank you. Everybody may be seated. Give me 1 minute to incorporate what you just sent me, and then we'll print this off, have you look at it. We'll take about 5-10 minute break, and then we'll get together and talk. Just so you know, I did highlight 305 just because to remember that we need to talk about it and finish our discussion. But I'll incorporate, actually, I'm going to have Christina, and just so, this was not on the record. There was Ms. Rude sent a proposed addition to 275, and I happen to overhear that there was no objection to it. Is that correct, Mr. Zachary?
The 275 as to Mr. Pedrin, yes.
Right, the part, and I was going to add that before the propensity language.
Sure, yeah, I agree, the state's version's cleaner.
Is that agreeable with the state?
It is, Your Honor. I think the indication was that it was okay to use the definitions of the pattern instruction. The only thing I indicated is that there's not a pattern definition for source of injuries. That one might be more self-defined anyway. The other ones, right, are more legal terms. But that was the only
Okay,
unknown there.
all right. So it's adding that and then the definitions of, I believe it was,
Yeah, the bracketed definitions in 275.
right. All right, that will take me a moment to do that. I'm not going to do that right here. But what do you, source of injury question? It's almost,
I think it's self-explanatory.
okay. All right. Well, we'll use the other definitions then. Anything else I should put in? In the jury instructions? Other than is there anything else?
To my knowledge, they're complete. We'll eagerly await our copies from Christina.
Yeah. And the state's okay so far, trying to incorporate that. Then the last issue are the verdicts. We are putting those together. One thing I did on count 3, which is normally we just say guilty, not guilty, then go to this question. I did put in that language that they must agree on about the event for either causing death or for great bodily harm underneath it. You'll take a look at it and we can change that if you want the order to be a little bit like that sentence before the sentence or after. But I did add that. That doesn't necessarily, I'm not sure I don't know if there is a standard verdict on this, to be honest.
I'm not sure there is, but I think that language is really important because they do have to be unanimous as to that fact.
Right.
I would agree with the unanimity language.
Yeah, I don't want to run into a unanimity issue by not having it there. So, okay, as soon as it's ready, we'll get you copies and I'll come back in.
Thank you.
Well, that kills all the TiVo time that we had, or we thought we was gonna have. Thanks, Judge. Thanks, Court. All right, thanks a lot, guys. That's the only thing about starting these trials and cases on time because of things like this. I have no clue. It just doesn't go straight through. Ouch. Man, I was cooking the other day and I burnt the crap out of my arm. And I just hit it. Where I burnt it. My bad, guys. Let's see here. Hey, Renee, welcome in. Welcome in to anybody that I didn't catch earlier. Let's see here. How long is our break? I didn't even, I'm up here looking at this, checking into this Alex Murdoch stuff. Oh boy, oh boy, oh boy, oh boy. Y'all know we're gonna have to rewatch that trial now. So I can hear him talk about Paul. Ay, 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 ay. My guy. 30 to 45 minutes. Okay, so we going into jury instructions and closing. Oh gosh, 30 to 45 minutes. See, this is what I'm saying. What a mess. Okay, that's cool. You say that's what the judge said. I don't think I got 30 to 45 minutes worth. And that's with our other trial. I was kind of like doing that with the Fooligan trial. I don't know. Let's see here. Do we need to relook at any testimony from this case? I can't believe they had the jury come in and that's what they did. Wait a minute. Well, let me check on our Fulio trial. You want to look at Derek's testimony? Well, there go the judge. What he doing? Y'all see him? What you doing, Judge? Let me see what they do on our Fulio trial. Unless y'all want to cover this Alex Murdoch stuff, I can set up a new room. We can do that real quick. Let me see what they doing in Fulio. Because when I went over there the last time, they were taking a break. Rebuttal. Okay, yeah, the state for Fulio, they got their rebuttal witness. Like these cases is running neck to neck today. Like rebuttal witness over here, break, rebuttal witness over here, and it's probably gonna be a break. Okay, so y'all tell me what y'all want to do. I'm gonna put a little poll in here so we can know what we're gonna do. because we can always open this back up once they start, and it may be a good look. So that way, I could put closing I can make us a new thing for closing arguments, jury instructions, and closing arguments. Because we about to go to verdict. Watch, run, run, girl, run, Josie, run. Please, girl, run. If you know anything like I know, run, girl, run. Yeah, I see why the state has their witness up there. Our boy Davion, he is shake. All I caught was he is shaking his head, like no, 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 no. Like he over there shaking his head like somebody did something to him. I don't know what that means, but I don't know what they really talking about. But yeah. Yep, surely did. Oh, let me get this. Let me get the survey out. Sorry. Yeah, yeah, I see that the prosecutor, my guy who prosecuted Alex before, he done spoke out. And I like him. I mean, I don't mind watching him again. That's why we're gonna watch his trial again. But I really like him. So I really like him. So there we go. So I'm okay with watching him many and plenty of times. So there's that. Okay, y'all make sure y'all answer the poll so I can kind of see what we gonna do. I only got one person that voted so far, and it's moving to Fulio. And if so, that's what we gonna do. Hmm.
You be seated? You be seated.
Maybe the judge gonna be coming back. Maybe we don't have enough time.
Did I bring, oh yeah, I did bring that in.
Oh, you gotta go nowhere. Come on, judge. I'm back. in all fairness, we probably had some TiVo time. We just didn't have all TiVo time. So we probably had some TiVo time. That's why it seems like it's really, really short. I didn't think about that. That may be why we do it.
We didn't print out the verdicts yet. Just realized that. There should be a cup. I'm gonna go check something quick. I'll be right back. I'll come to the side. You don't have to do all the rest.
When I keep seeing him go up and down, I just keep thinking, pop goes the weasel because the weasel go pop. Hey, Sin. Like, sit down. They talking. We can't hear it though. Oh man, I don't know what he's doing. He ain't talking about nothing. We can't hear it. I know he's tired of this case. I am too. I think Josie should run, but that's just my opinion.
When the live stream flickers on and Sweet Pea takes a stand, Lynn is already there, coffee in hand. She settles in for the long trials, the twists and the turns, with a loyal heart and steady eyes that never miss a word. She's a constant in the courtroom, a familiar shining face, always ready for the arguments, the tension and the pace. And when the evidence is messy or the stories sound untrue, she leans forward just a little. Lynn knows what to do, 'cause Lynn thinks everyone is guilty, every suspect, every tale. Melody Ferris guilty, she says without fail, but Dr. Rachel shakes her head. sure the sun is to blame. Still, Lynn stands firm, her verdict stays the same. Oh, she brings the truth with a calm, steady light, and her presence is a comfort on every trial night. She listens with devotion through each objection and plea, through the cross exams and pauses. She's where she needs to be. In the sea of courtroom chaos where tempers sometimes flare, Lynn remains unshaken, a voice of reason there. And though the check may chatter and the theories may divide, Lynn's perspective never wavers. She speaks with honest pride. She keeps the room grounded when emotions run loose. A quiet force reminding us she's here to find the truth. Yes, Lynn thinks everyone is guilty, that's just her way. From the first opening statement to the end of the day, Dr. Rachel can argue the son's the one at fault, but Lynn won't budge. She's rendered her final thought. We appreciate her always for her loyalty and her proof, 'cause the church shines a little brighter when Lynn brings the truth. Yeah, lights on, chat awake. What's the move tonight? Sweet pea in the room, yeah, you know the vibe, right? Quick, sharp mind cutting through the noise. Got the whole room laughing when she drops her voice. Eyes on the screen, yeah, she reads the whole room. From just the fact she's ahead of the boom. Not just a talk, yeah, she bringing receipts. When Sweet Pea speaks, everybody hits repeat. She don't just show up, she sets the tone. One laugh from her in the chat's blown. Smart, funny feelings, yeah, that's the code. Main character energy fully in mode. Whoa. Sweet Pea, say it louder when she enters the scene. Sweet Pea, got the jokes, got the facts, got the mean. When she talks, everybody leans in. Sweet Pea, yeah, you know she always wins. One line of queen, yeah, she never miss. Turn a quiet room into a viral clip. Brains and humor in a perfect blend. When Sweet Pea starts talking, that's the trend. Say it again, who runs the chat? Sweet Pea, yeah, that's that. Sweet Pea, yeah, you know she always wins. To the courtroom stream, SD walks in like she owns the scene. Pelo multicolor shining in the sun. She cracks one joke, chat laughing as one. She throws preguntas bien chidas, sharp like a blade. Cross exam queen, nunca tiene afraid. And that dance so spicy, Cali Mystics close. She brings the fuego, everybody knows. Cuando Jason llega, ay caray, she flirts poquito. He just says hi, Sweet Pea laughs.
Instructions, we'll deal with the verdict. I already see there's some problems with the verdict, but we'll deal with that second. Okay, page 1, standard, page 115, or page 2, which is 115. Any corrections to page 1, 2, 3, 4, and goes for a while, 5, 6. Any corrections from the state's perspective on 115?
No, Judge.
State or defense?
No, Your Honor.
Okay. So that takes us to page
Oh, Judge, I was specifically referring to count 1. We do have a minor change in count 2 on page 9.
Yeah, I was just getting there.
Okay.
No, I'm just talking about count 1. Now we're on count two. I'm sorry. I meant count one. Now we're in counting chronic neglect of a child consequence. Where's the, what needs to be changed?
On page 19, excuse me, yes, 9, thank you. It should be action or failure to take action, which is what the language is on page 10 when the elements are described.
Can you just say what?
Yes, so Josie Dikeman, reading the charging language there, being a person responsible for the welfare of a child through her action, and then it should be or failure to take action for reasons other than poverty. That language is already on page 10. Just
Right. Yeah. Do you agree with that, Mr. Zacher?
I think that's what the court ordered yesterday.
One more moment. Why did it do that? Sorry, it's all of a sudden I did that and all the spacing got strange. What the hell? Okay. All right. Anything else in count two?
no, Your Honor.
Anything from the defense? All right, hearing none, we'll go on next to.
I'm still scanning, but I.
Oh, okay, go ahead, sorry.
All right, yeah, we can go to, no one else.
Okay. Hold on one second. I don't know why is that happening. Right. All right, going on to count three, which is on page 13. Any from the state, any changes?
No, Judge.
Same, with the same unanimity objection that I made previously, no objection.
Okay. And then 140 is standard. We did make that change to reasonable hypothesis yesterday. Spacing is all funny now. Hold on one second. Anything on 140?
No, Your Honor.
No.
So then we get to 145 and 103. Any corrections to that?
No, Your Honor.
No, Your Honor.
170, 155, any corrections?
No, Your Honor.
No, Your Honor.
So here's 275 with the modification that we've added. I just put evidence presented for Josie Dikeman, evidence presented for Derek Pedrin as a way to distinguish the two as headers. That's one addition, plus I added obviously the definitions below.
Judge, I think there are some changes in the definitions for Mr. Pedrin, because obviously the pattern instruction is designed for defendant.
Oh,
So
yeah.
we need to change defendant in there, or the defendant to Mr. Pedrin, and then I think probably change offense charge to conduct alleged
Yeah,
for each of those.
yeah, it was quickly done.
No objection to that.
Obviously, that needs to be done. To conduct alleged.
I think that fits best.
Any objections to that?
Judge, I distracted by the noise outside. Which section?
So we're still on definitions of Derek Pedrin. So it says right now, opportunity, that is whether Mr. Pedrin had the opportunity
Yeah, no objection.
to
Objection to swapping.
commit to,
I think just relating to the conduct alleged.
so it'd say whether Mr. Pedrin had the opportunity relating to the conduct alleged.
I would say like whether he had the opportunity at the conduct alleged.
Yeah, I think if we just change offense charge to conduct alleged for each of them.
I need one more word in there, though. That's the problem.
For each
To
of them,
commit conduct alleged,
commit the conduct.
the conduct
Alleged.
alleged, yep. Intent, whether Mr. Pedrin. Active. Okay, so this is how that paragraph will read. So definitions for Derek Pedrin, the evidence was received on the issue of motive, that is whether to, excuse me, I know I missed one, that's why I read it out loud. Whether Mr. Pedrin has a reason to desire the result of the conduct alleged. Opportunity that is whether Mr. Pedern had the opportunity to commit the conduct alleged. Intent, that is whether Mr. Pedern acted with the state of mind that is required for the conduct alleged. Identity, that is whether the prior conduct of Mr. Pedern is so similar to the offense, the conduct alleged. That it tends to identify the defendant as the one who committed the conduct alleged. Context.
Yeah, we're,
The defendant, thank you. I find that Mr. Pedern. As the one who committed the conduct. So it says, let me go back. Identity, that is whether the prior conduct of Mr. Pedern is so similar to the conduct alleged that it tends to identify Mr. Pedern as the one who committed the conduct alleged. And then finally, context or background, that is to provide a more complete presentation of the evidence relating to the conduct alleged.
Good.
All right.
I think we have the same issue or slightly different issue in the propensity-free reasoning part.
Yeah,
Because that's still just relating to Ms. Dikeman.
just hold on one second.
Judge, I think we could just change that to because a person committed another act or crime, they probably acted the same way again.
Mr. Zacher.
Judge, this is another one of those scenarios where the constitutional rights belong to Ms. Dikeman, not to Mr. Pedern. I think the language is appropriate.
Even with character, though, Your Honor, you can't argue propensity.
I'm going to leave that as because the issue you run into with the propensity-free reasoning is really paramount on the issue of the defendant. There are other issues that come in. It's as seen, 275 was originally designed to be for defendants. That's why we ran into the issue. I'm just going to leave that as is. Yeah, I mean the propensity-free. It's explaining an example anyway. That's what it really is doing. And then the very last phrase needs to be there because that's correct about Ms. Dikeman.
Sounds good.
Yeah, all right. So 157.
Objection.
No objection.
150, I should 148, 147, 150.
Looks good.
No objection.
Hold on one second. 158, 190.
Standard instructions, no objection.
Yeah. I did have to modify 158. Is that okay?
Yes.
Yeah, it's fine. It's modified.
Okay. 190, 195, and then 195, 200, and then 205.
Good.
All standard, no objection.
300, standard,
No objection.
3,
No objection.
325, 327. We changed those.
And
No objection.
340.
No objection.
no objection.
And then I made the decision not to include 305 in the end. I decided that it's, there's too many issues that come up with it. It's not recommended. You can make arguments, obviously, during closing. And then back to this 160, 465, and 484. Let's do 160, 465 first. Any problems with that?
No objection.
Okay, 484. I'm just wondering. I think in night, I was going to add, so this gets to the verdict question. What I was going to add at the bottom of maybe before the dated line on, so if we're looking at count one, verdict, page one, that I would add if you if you're if you find Josie Dikeman not guilty of count of first degree intentional homicide, go to page 2 and then, or go ahead, or do you have better language?
Because the way I usually see it done is that it says first degree intentional homicide. It just says guilty. Then there would be a second one for first degree reckless homicide that says guilty. Then there would be a third form for second degree reckless homicide that would say guilty. And then there's a fourth independent verdict form that says we, the jury, find the defendant not guilty as to count one.
Yeah, that's how we did it in a number of other cases. That would be my preference as well.
Okay, all right. So we'll, I have to admit, I don't have very often, especially this one. So you would just have everyone listed. Do you need to have a line that if you find them not guilty, just
Because they're not necessarily finding not guilty, they're just saying they can't agree. So then they're moving on to the next one to consider that one. That's how the instruction tells them. It says if they can't agree on the higher count, then they move on to the next one. Not that they're making a finding of not guilty on those higher counts.
should that line be in there? If you cannot agree on
If
this
you
first
wanted,
count?
I think you could add a line as to each one. If you cannot unanimously agree as to first degree intentional homicide, you must consider the next lesser included offense. Then, but it's up to your honor. Otherwise, I think we'd be fine just having a guilty for all the three, and then having a not guilty as to count one is the fourth.
If the court still has the instructions from the Mitrell Anderson case, that was the language we used.
Well, that might be helpful. Hold on a second. Oh, that's a long time ago. I'm not sure I have that. All right. So assuming we change that, that's in count one. Count two, any problem with the language in count two? And oh, by the way, what I would do is 484 would then change to reflect whatever we end up doing. Count two, any problem with how count two is listed there?
No.
Reserving our earlier objections, no.
And then count three. I think the language,
I think you just have to add under the first question.
yeah,
To answer yes, you must agree on the violation that caused death.
yeah, I would put it, yeah, I would put exactly the same line. For some reason, we just don't have that there, but that would be the one change I would make. It would say to answer yes, you must agree on the violation that that caused death. Yeah. That makes sense, Mr. Zacher.
Yes.
Okay. I'm gonna make those changes. We're gonna go make those changes and then I'll be right back and we'll do that last little part. Otherwise, I think we're doing good on the.
Yeah, does the court want to address the verdict forms now, or?
That is I'm gonna address the verdict forms and change one. We would change it to what we just talked about. Or is there another issue?
Yeah, my request would be to require a 4-person signature under the jury questions as well on count 3.
Any objection to that?
Sure, that's fine.
Okay.
I mean, no objection.
Yeah. All right, we'll try 4-person signature. Okay, well, we'll have to figure out how to do that format. All right, I'll be right back.
Aquí vamos otra vez. SD drops a fuego in the chat says yeah. She's fuego, fuego, lighting up the show. Text next in the chat. Everybody knows con su risa, su vibra y su pelo tan cool. She turns the live stream to a cumbia at the pool. Fuego, fuego, SD's the queen. Spanglish magic en la chat screen. When she pops on camera, we all say que show. Latina sparkle with that California glow. Los mos la quieren, they hype her name. She adds flair y sabor to the game. ¿Qué onda, gente? And here comes the fun. El chat se enciende like under the sun. When she teases Jason, boy, behave. But without her chaos, this chat ain't the same. Bailalo, mija, with your Tex-Mex vibe. Bring the cumbia flow, keep it alive. Stay with the groove, don't ever stop. Shake up the stream till we're all on top. She's fuego, fuego. Let her up the show. Tex-Mex in the chat. Everybody knows con su risa, su vibra y su pelo tan cool. She turns a live stream to a Latin dance floor. Fuego, fuego. SD's the queen. Spanglish magic en la chat screen. Each girl sparkle, courtroom delight. SD keeps the chat shining bright. Sweet pea, the mods, we all agree. Take it to trial, ain't the same without SD.
Yeah,
Yeah, yeah, yeah. Yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in check. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the California's rolling deep on 9. 4 corners, one crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
yeah. SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how
She
far.
got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie.
Josie, Shamrock, Shamrock.
Junkie, 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 junkie.
Josie, Shamrock,
Where
Shamrock.
we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this. Yeah. Ooh. Californians, Californians, yeah.
Man, oh man, I tell you. Hey, Java Queen. Hey, Madonna. Let's see. Okay, so I'm just hoping that we are going to get into jury instructions and get into some closing arguments because I'm like the judge, like I'm so over this trial. This case. If Josie knew what I knew, she should have been running. But she don't know what I know. I see the judge. I see his head. Bald like an eagle. Bald like an eagle. Come on, Judge. Put your robe on and come on back. I don't like when they get to this part of the trial. It just seems like it's forever. It just seems like they do too much when they get to these parts, and I don't understand why. Like, what is the deal? Like, y'all can't figure this out before the trial starts? Like, what the fudge? What the fudge? Like, we should have something different. Like, it's not going to be the standard jury instructions because we don't have every trial is not the same. But come on, guys. Give me a break. Give me a break. Baby, come back. Baby, come back to me. And I know y'all don't want to hear my horrible ass singing. Y'all know out of any phase, anything, I can make a song out of it. Or it's a song that goes with it. Oh man, I want her not to show back up after lunch. I want her attorney to have a real good talk with her, like, boo, we tried, we lost. You probably not gonna win this. So I'm gonna open the back door for you. Take off your bracelet and let's just run. I'll even give you a head start. You can use my car. Don't worry, I got insurance on it. Whatever you do. 90 minutes? Like, it is not that much to talk about in 90 minutes. What the fudge? I don't have anything to talk about for 90 whole minutes. 90 minutes? That's longer than the 4 defendants that we got in the other trial, man. That should be a crime. That's why, a lot of people was like, y'all, just to be very candid, a lot of people was on the, we did a premiere this morning. I don't know if you attended or not, but we did a premiere this morning. And everybody was like, why is he, why is why is it so sped up? They kept asking me, like, why is it so sped up? That's what I see in the comments. And I'm like, the reason why it's sped up is because if you listen to this in real time, either you gonna die from boredom or die from breaks. Good grief. And the judge feeling it too. The judge like, okay, so now I got to figure out where to put a signature place for the 4th person. Like, I guess I can figure it out. Like, why do y'all got to be so difficult? Why can't this stuff just be what it is? It's like crazy. Yeah. So I don't know. I just don't know. Ooh, shout out to Susie Q. Thank you, thank you, thank you, honey bun. She said, I'm invested in that one too. I'm being nosy in the chat now, for real. Says, yes, I'm invested in that one too. The suspects are refusing to tell what a little body is. Only one been charged so far, 3 other suspects involved. Which case is that? Martina said, I'm sold. I want to see it. Which case is it? I don't know which. I'm trying to figure out. I know I'm a little behind. Y'all are behind me when I'm speaking. I'm trying to go back up in the chat. I must have missed it. I don't know. I'm trying to be nosy. Okay, y'all eventually tell me what case it is. Okay, let's see here. Did anybody see? Were there any new cases that's coming out for next week? Michael Monkey, Mickey Monkey. I don't know what y'all talking about. Okay. Mm. I'm being nosy now. Trying to see what's out here. Since we waiting on our judge, and our jury. The judge, the jury.
Yeah, late night glow from 1,000 screens. Everybody watching, nobody seeing the same thing. One line drops, 10 disappears. Not here for drama, not here for the show. We're here for the patterns that nobody else knows. We're the signal in the noise. Low voices, sharp choices. Every thought hits like a flare in the dark. We're the signal in the noise. No scripts, just voices. When the chat moves, yeah, it leaves a mark. Someone jokes, someone pulls the facts, someone notices what they tried to hide in the gaps. No spotlight, but the room feels tight. Truth doesn't shout, it arrives quiet. Different minds, same frequency, not followers, we're a community. They think it's random, they think it's luck, but patterns don't lie when you look long enough. Say it's soft, say it's slow. Who really runs the flow? Not the screen, not the host, it's the chat. Yeah, you know. You know.
It's after dark, where the filters fall, where we talk about the things you don't say at all. Sweet peas in a chair saying tell it how it is. We unpack real life, not just courtroom biz. It's opinions, confessions, messy and true. Real talk, real laughs, and a grown-up view. Not gossip, not drama, it's truth with style. You can plead the fifth, but we'll still see you smile. We don't tiptoe around the hard conversation. Oh, oh, oh. We break it down with truth and speculation. Hey, therapy, law, comedy, insight. That's what trial talk sounds like at night. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial. After dark tonight. Film freaks got receipts in the hidden scenes. TYK breaks it down like a therapy machine. Rachel keeps the facts sharp, logical tight. Pretty brown girls got the clapbacks on sight. Fowler keeps the peace, well she tries at least. Morelia drops gems when the topics get deep. And Jason walks in with that wise guy grin. And the chat yells, here comes the chaos again. Not late night drama, late night perspective. Big brain debates that get introspected. It's real, it's bold, it's thought and fire. And it hits different when the lights get quieter. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial after dark tonight. Oh, 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 oh.
Yeah, Hey, get the trial with you. Susie in the chat, don't miss that, don't miss nothing. Yeah, log in early, she already there. Chat roll fast, but she don't even care. Trial on screen, notes all tight. She clock every detail morning to night. Karen read facts, she got the file. Timeline sharp, receipts on dial. Ask one question, she got three. Breaking it down like legally. Don't blink, don't lag, don't step away. She ain't miss one stream, now one day. Susie locked in, she stay online. If it's life coach, she front row prime. Full more hit, yeah, she feel that heat. But she still got answers before you can tweet. Hands up if you know she right. Life drag queen in the chat all night. Call it love, yeah, that's her lane. Smooth like the judge with a no-gear game. Dropping ideas like run that round. Name that case, yeah, she hold it down. 911 clips, she already knew. Before the host even gives the clue. Inside jokes, yeah, she locked in tight. Every verdict day, every late night fight. Mods look over like Susie got it. If knowledge of sport, she already spotted. feet, keep one eye. Life outside, yeah, maybe later. Right now it's court and the chat getting greater. Yeah. Susie locked in, she stay online. If it's life court, she front row prime. For more hit, yeah, she feel that heat, but she still got answer before you can tweet. Hands up if you know she right. Life track queen in the chat all night. Bald head love, yeah, that's a lane. Cool, calm, collected, no stress, no strain. No strain. Cool, calm, collected, no stress, no strain. No strain. No strain. Yeah. Susie in the chat, don't miss nothing, that's a fact. Take it in the chat, yeah. Life trial queen, yeah, that's you.
You know, I was just thinking to myself, this right here is a bummer. Like, oh my goodness. I guess the judge is really having a hard time with figuring out how to get the foreman signature on here, guys. I don't know. I just put a new cup of coffee on. Did anybody see any upcoming trials for next week? Just curious. Let me go over here. I'm going to Courtroom, Court TV. Hello, Z. Yeah, I don't see anything for next week so far. They probably won't put anything out until Friday. I'm thinking Friday is when we'll get it. Friday or somewhere on Sunday, maybe. I'm just looking at this. Mm. Susie, Caleb's trial has been pushed back to September. I kind of figured they was not going to try that case that quick. I knew they wasn't. I just couldn't imagine, like, it just happened. It almost reminded me of when they tried to act like they was going to try Sarah Grace that quick. Like, yeah, right, dude. They can't have that stuff together the way they're supposed to have it. Nope. Absolutely not. Yeah, so I looked yesterday at the court documents and it's not going to be until September, which I kind of figured. So we kind of right about that part of it. Mm. Let me go in here. Yeah, I had made the video. Did y'all hear her? Let me see. I made the video. I just didn't. I didn't post it. Oh, I probably can't get it from here. Wait a minute. Let me see if I can get the video. I thought I had put it up there. Oh, okay. No, I didn't. So maybe I will put it up there, but let me show it to y'all. It's only 20 minutes long. So just in case some of y'all missed it with her testimony. Let me see. Can I watch it? I got it private. Okay. Okay. So right here, I'm replaying some of her testimony just in case y'all can see this. In case y'all just didn't see this, this way y'all can know. You say Sarah Grace, well, the day we were supposed to start trial, the state came in and they didn't have a report that they quote unquote needed, so the trial got pushed back. So this is her on direct, our girl Josie. Maybe they late from court because they trying to find Josie. Maybe she took my advice and ran. I don't know, but it don't take that long to add a dang on signature line to a jury form, does it? I guess so. All right, here we go. I want y'all to listen to this. I didn't post it yet. Maybe I should post it. Maybe I'll post it after we finish watching it.
Received. Josie, I'm showing you what you drew here. So you would be on the side of the bed closest to where you were on the side of the bed closest to the nightstand where you had your medications.
Yes.
Was that the medication that you took on a daily basis on the nightstand?
Yes.
And it looks like next to you or to your left would be Brandt if you're all facing face up, correct?
Yes.
And next to Brandt would be Araya?
Yes.
And at the other end of the bed was Alex?
Yes.
Why was Alex on the other end of the bed?
Because he had a walker.
So you had the walker position where you could get him to the walker if you needed to?
Yes.
Did Alex sometimes need to get up at night and use the bathroom?
Yes.
Was this common for all of you to sleep in the same bed, kind of like Charlie in the Chocolate Factory?
Yes.
Was anything out of the ordinary with the fact that the kids would be in bed with you even after Derek got arrested?
Yes.
Or was anything unusual about that?
No.
Sure. And what size bed did you have, Joe?
Okay, I'm not gonna pause it too many times in between this, but I have to say something. Thank you so much, Buddy, and anybody else that is new subs, even if you're on a replay gang. I truly appreciate you guys. It's so funny because when I see his name, or when I see the name Buddy, do y'all remember the dial, My Buddy? Am I really showing my age? Y'all remember that dial? It was like a toy. It was like my buddy, wherever he goes, I want to go, my buddy. Y'all remember that? Oh God, TMI. I better stop. I'm gonna find a commercial. I remember that. It was kind of like it was the onset to when they started releasing Chucky. You know, the movie Chucky that scared the crap out of everybody. But we did used to have a my buddy. You remember my buddy? Nothing's wrong with my buddy. Oh my goodness. So just thinking about it, see his name, it just reminded me of my buddy. It was just the happiest thing for people to have. So awesome. But definitely thank you so much for hanging on up. Coming on over here with us. Now I can think about that. It was like a happy time for kids until they brought out Chucky. And I was like, oh my gosh. Oh, Michael, you might be at the wrong place, boo. You might have to go where they don't do any commentary. Yeah, I'm sorry. Oh man. So we'll go back into this. You remember it then? Yeah. My buddy. That was an awesome time. Oh, wow. Okay, guys, we will go back in while they are on break. Hopefully, they'll be back from court soon. But this is just her on direct the other day. I don't know if a lot of people caught this when because she kind of like describing, this is the portion where she's actually describing the unaliving when she found him. Okay, so here we go, guys.
Was he?
King size.
Okay, so it was a fairly large bed.
Yes.
Did you do anything in bed with the kids after you all lay down?
No, but I want to correct something. I think I had told Alex to wake me up if he wanted his walker, just to make sure he woke me up.
Okay, thank you. And why did you feel the need to give him that warning?
Just because I wanted to make sure that he had an adult present. I wanted to make sure he woke me up.
Was it pretty normal for you to watch movies or TV shows with the kids in bed?
Yes. It was common for us to have popcorn and watch movies.
Now, did you watch movies or shows that night that you can remember?
Yes, we did.
What do you recall watching?
It was popular for the boys to watch Mary Kate and Ashley because I called them my twins.
Okay, so they thought they were like the Olsen twins, so they watched that.
Yes.
And at some point, did all of the kids go to sleep?
Yes.
Who went to sleep first, if you can recall?
I don't know.
It wasn't Alex, as I understand it.
It wasn't Alex, but thinking back, he wasn't like fully awake.
Okay. What seemed off about him?
He was being silly.
What do you mean?
He was like playing with his hands in the air.
Playing with his hands in the air? Is that a yes?
Yes.
Did you have any reason at that point to suspect that Derek had given him drugs?
No,
You just thought he was being silly?
I thought he was being silly.
Now, while you were in bed, were you talking to Laura Lee?
Yes.
Just generally speaking, how would you describe the tone of that conversation?
We were just talking about me going on the date with Raphael and
Was it a pleasant conversation?
yeah,
Were you excited to go meet Raphael the next day?
yeah.
Did you do any planning online for first date planning?
Yeah, I didn't know of many coffee shops, so I was Googling coffee shops around in the area.
So was that the plan, just to meet Raphael, get coffee, and hang out for an hour or two?
Yeah.
Just get to know him.
Right.
Were you mad at all at Alex or any of the kids when you were texting back and forth with Laura Lee?
No, I mean, they were all in bed laying there. I wasn't upset at all.
How about at any point in the night were you upset with the kids?
No.
Now, we've already agreed that you had some 164, I think, text messages between you and Raph that evening. How were you feeling talking to Raph?
But fine, I was interested in getting to know him.
Anything about that made you angry?
No.
When you were in bed, do you recall having a phone call with Laura Lee?
Yes.
And what generally was the tone of that conversation?
I was asking her questions about Raph and
Happy?
Yeah, it was a good, happy conversation. We were talking about Derek getting arrested and welfare check.
Okay. How about, did you take a series of selfies with Brantley?
I did.
How did that end up happening?
Well, I was taking selfies and he popped his head in.
Publishing has already been marked and received. So around, I think at some point between 9:06 and 9:15 p.m., you took a few photos with Brantley.
Yeah, my face, that was a forced smile. I did not feel good.
Was Brantley photobombing you?
He was.
Did he think that was funny?
He did. He said, "Mom, take one with me."
And how does Brantley look to you in this picture?
Happy.
How do you look?
Well, my face was really red. I wasn't feeling good.
Okay. Do you look angry, Josie?
No,
And when you took these selfies, where were you taking them?
in bed.
With Brantley next to you, as you indicated on the diagram?
Yes.
Is that where Brantley slept for the remainder of the night?
Yes, Brantley was a mama's boy.
So on your call with Laura Lee, do you agree with the testimony that there was some discussion about Alex waiting for you to go to sleep so he could get up and get into things?
Yes,
Tell us how that happened to the best of your memory.
I remember that discussion. I mean, that was the last thing Alex said to me. I said, he was playing with his hands in the air, and I said, "Alex, are you waiting for me to go to sleep so you can get into stuff?" And he said, "Yes," like that.
You thought that was silly?
I thought he was being silly.
Were you joking with him at that point, or
I
was
was
there an
joking
element?
with him.
I'm
and
sorry.
I was joking with him.
Did you actually expect him to get up and go through things at night?
No,
So, Josie, at some point, well, just to cover the text messages, would you agree that it was pretty consistent that you were texting back and forth with Raph until about 2 a.m.?
I don't remember the times, but yeah.
Until a little bit later in the day, night
Yeah.
is it, or early in the morning, I guess. Would you agree that your contact with Laura Lee was pretty consistent throughout that time frame?
Yes.
And during that period, were you hurting Alex at all?
No,
Were you giving Alex Xanax or any other drugs?
no,
Is that something that happened at all that evening?
no, it did not.
If, knowing your children, Araya and Brantley, you believe that you would be able to beat Alex up in the room and not wake them up?
I believe they would have woke up. They wake up to Derek beating me.
So the state asked, or the state introduced some search history for the drug Ambien. Do you think that you looked that up on the search engine?
Yes, I believe that was a conversation Laura Lee and I were having on the phone, and we were talking about it, and I looked it up.
Did you actually have Ambien?
No,
Did you have a prescription for it?
no, I think she had it when she was in the hospital. I think they gave it to her.
And at any point, would you have given Ambien or what you believe to be Ambien to Alex?
No, I've never had Ambien, never had it in my possession, never have had it in my system. It was just looking it up. I believe she was given it in the hospital, and she was asking, what is it?
So with Alex having issues getting up and sneaking around, was that what you were referring to with Derek when you said that a parent needs to be with him all the time?
Yes,
Did you eventually go to sleep that night?
yes, I did.
And I want to ask you a little bit about some of the medications that Alex was taking at that time. Was he taking any medications?
He was taking ibuprofen and Tylenol as needed,
What kind of ibuprofen and Tylenol? The adult version or the kids' chewables?
kids' chewables.
Did he know where those pill bottles were?
I mean, I don't know if he knew they were in my purse.
How did Alex do taking chewable medication like that?
He thought they were candy.
So he had no problem saying that this is yucky or this is gross?
Mm-mm.
I don't know.
No, sorry.
Okay. Did Alex do well taking other medication that kids tend not to like?
Yeah, he did really good taking like medicines from the doctor. He wasn't my struggle compared to like Brantley. He was very hard to get him to take medication.
How about that liquid amoxicillin that doctors give to kids? Did Alex ever take that?
He's had to take it, yes.
How did he do with that?
Pretty good.
Did Alex ever eat anything that you thought maybe he shouldn't be eating in terms of food or things on the floor?
I always called him a little garbage disposal because he could eat and eat and eat and he didn't know where it went. But like in the van, I swear finding a piece of candy was like Christmas for him, and he'd pick it up anywhere and eat it.
The other kids think that was gross?
Yes,
So the allegation has been made, Josie, that you were upset with Alex for stealing Taki chips. Is that true?
no, Alex didn't eat Taki chips.
What did Alex eat?
If it was hot, he would eat hot Cheetos.
I want to talk to you a little bit about how the kids said that Alex would steal things. Had you ever caught Alex stealing from a store before?
Yes,
Irrelevant.
It explains this. It explains the statements in the reputation, Judge.
That's not what the kid said.
You're saying that,
I'm asking who was present for it and when, what Josie's response was to that.
oh, okay. Over,
Okay. Have you ever caught him taking something from a store before?
yes.
And what did he take?
My object, this is not in other acts. It wasn't noticed. It wasn't,
Response to this, the testimony of the state's witnesses.
which was known. They had the videos. This is not other acts. This was not offered.
The testimony was not consistent with the videos.
which video are you talking about?
Where Brantley and both Brantley and Major talk about being known for stealing.
What's in the videos and it was known.
Okay, it's late. I don't know. I can't remember what was said in there exactly about the stealing aspect. You're saying that they were saying that
They would have known about this incident when they talk about mom being upset with him for that.
oh,
Not,
th-
just we have a sidebar because
So Josie, your phone activity showed that you were inactive for about 6 hours between 3 a.m. and 9 a.m. Why was that?
I was sleeping.
Would you have been able to go to sleep if you had just eaten Alex up?
No,
Did you have any reason to believe at the time that you went to sleep that something was wrong with Alex?
something was wrong with Alex. I went to sleep.
Now, I want to talk about the next morning.
What do you recall doing when you got up?
First thing I did when I woke up was look at my phone.
Is that what you normally do?
Yes,
Would you have looked at your phone if you thought that something was horribly wrong in the bedroom?
no.
So what did you do once you looked at your phone?
After that, I, took what medication I had,
Okay.
and then I stood up, and I thought I was gonna get ready and take the kids to my mom's.
Did you text Laura Lee at some point when you were looking at your phone?
Oh, yes, I wrote her. She had sent me a message about a sensory swing for her autistic child, and I said, cool.
Okay. And what was your state of mind when you sent that response?
I had just woken up and I was about to get the kids ready to take them to my mom's.
Do you think everything was fine at that point?
I did.
So when did that perception change that everything was fine?
I stood up and I turned around and I only seen Brantley and Araya on the bed.
What did you do when you only saw Brantley and Araya on the bed?
My heart dropped and I didn't know where Alex went. I started looking around. He wasn't on the couch. I walked to the other side of the bed and I seen him laying there.
How did Alex appear when you saw him laying on the other side of the bed?
He looked gray. He had foam in his mouth. His hand was sticking up.
Be clear, was he on the floor at that point?
Yes.
What did you do when you saw Alex in that position?
Told the kids to go upstairs.
Did they go upstairs?
Yes.
What did you do after the kids went upstairs?
I started crying and I went over to him and he was cold.
Did you try to do anything to help him?
I tried doing what I thought was CPR.
Tell us about this CPR lesson. How long ago was that?
I was young, I think.
And when you said that you were doing CPR, did you have a chance to see the other first responders doing CPR?
They were pushing a lot harder than I was.
So when you started pushing on Alex, tell us about the foam. What did you notice?
Foam kept coming out.
What did you do when the foam kept coming out?
I kept wiping it.
What color was the foam?
White and yellow.
And when you kept wiping the foam and pushing on Alex's chest, at some point, did it become apparent to you that he had passed away?
Yes, and I tried blowing in his mouth after I wiped the foam out.
What did you do once you stopped doing CPR?
I held him,
What were you doing when you held him?
cried.
Were you saying anything to Alex?
I was begging him to come back.
Was it apparent to you at that point, Josie, that Alex had passed away?
Yes. He was stiff. He was cold.
What was it like in that moment for you?
I didn't understand. I thought he was fine when he went to sleep and he wasn't.
Josie, did you time how long you were doing CPR?
No.
When you said 10 minutes, was that an estimate?
Yes.
You're holding Alex on the floor. You're crying with him. You're talking to him. What do you do after that point?
Call my mom.
Does Alex go onto the bed at some point?
After I called my mom, I held him more and I cried and I begged him to come back and I cried and I told him I was sorry that I wasn't there when he needed me.
Did he?
And
Go ahead.
I knew that they were going to take him when I called 911 and I just wanted to hold him before they did.
Had you picked him up and put him on the bed at that point?
I was holding him on the bed, yes,
Why didn't you call 911 right away?
because I knew he was gone and I didn't want them to take him.
You wanted to hold him one last time?
Yes.
Why did you call your mom first?
I wanted to believe that there was something she could do, something that would bring him back.
Josie, when the police arrived, do you feel like you had a good memory of that day? That was a really poorly phrased question. Let me rephrase that. You have a good memory of everything that the police did and asked you about when they responded on February 11th?
Everything's a blur about the police and everything after seeing Alex's face.
What's your reaction when you've been accused of not showing enough emotion when police were doing CPR?
I can't help how my emotions are. I can't help that I don't show emotion like other people do. But I know what my heart feels. And I know that I miss him every day. And I know that I love him with all my heart. And I know that I did not hurt him.
In a moment. Josie, were you crying at points on the 11th?
Yes,
So we saw your interview with Lieutenant Williams. You remember seeing that in trial?
yes.
And how would you describe your emotional state at the time that you talked to Lieutenant Williams? How were you feeling? Let me ask you that.
Felt like a living nightmare. I was in shock.
Did it seem real to you that Alex had passed away?
No,
Why did you tell Sergeant or Lieutenant Williams that you thought Alex got into your medication?
because I seen the foam in his mouth, and I assumed with the foam in his mouth it had to be an overdose. And
Were you paying close attention to your room the night before Alex was arrested, or before Derek was arrested?
no,
Do you know whether or not Derek moved that pill bag and used a bottle to stash his Xanax?
I don't know what Derek did with his Xanax.
So was it your immediate perception that Alex must have gotten into your pills?
That's what I thought.
Were you trying to share what you thought was important about that with Sergeant Williams?
Yes,
And Josie, during that conversation, did anybody ask you about whether or not Derek had ever been violent with Alex?
no,
Did anybody ask you whether or not Derek used illegal prescription drugs?
no.
And you said that it all felt like a dream. What did you mean by that?
I went to sleep and Alex was breathing, and I woke up and he was on the floor, gray and lifeless.
What did you mean when you told him that you just wanted your baby back?
That's all I wanted. I just wanted him back. I didn't. If I could do anything to trade places, I would.
Recall Sergeant Williams asking you for your telephone. Take him out. Another minute, Josie. Why'd you give it to him?
Because I didn't have anything to hide.
You give him your passcode for the phone as well?
Yes,
He had asked you for access to the camera apps. Would you have given him access to those?
yes, I would have given the cameras. He could have took them.
Did he ask you any follow-up questions about what you meant when you said that Derek was on bond for choking you and getting aggressive with you?
Can you repeat that?
Did he ask you any questions about what you meant when you told him that Derek was on bond for choking and getting aggressive with you?
No, he didn't ask anything about the violence.
Did anybody ask you for access to Derek's devices?
No,
Did you have handed over anything that was in the home if they wanted to examine the device?
yes,
So, Josie, you actually tell the officers that you believe that Alex got into your medications. Is that right?
yes.
Were you blaming yourself at that point?
I thought it was my fault. I thought he did get into something of mine while I was sleeping.
The allegation has been made repeatedly that you staged the scene to make it look like an accidental overdose. Did you do that?
No,
And do you have any idea when that prednisone bottle was actually placed on the ground?
I do not.
Did you put materials around the pillows or around the bed or anything like that?
I'm sorry.
Did you take inert pills or medication that wasn't harmful and leave it around as a distraction?
No,
And Josie, I got to ask you again, why didn't you tell Lieutenant Williams about Derek's behavior the evening before?
I was terrified of Derek.
Did you have any reason to believe that this was anything other than just another day with Derek being violent with you and the kids?
Yes, I did not see what went on in that bathroom. I only know what I heard, and he denied it.
Was it
And
even on your radar at the time that you talked to Lieutenant Williams that this might have been a possible cause of death?
the only thing that was in my head was my baby laying on the floor, dead.
Oh,
So, hey, man. Let me see. He said, I take it. I was here for the Julio trial, but I'm going to step back out. Step out. Okay, no problem. We'll be in the Julio trial in a little bit. So yeah. No problem at all. Yeah, we're gonna go over there. We'll be watching that soon. We're about to go into closing arguments here, so I guess we'll do this part and then go over there. Nick, is that what it was? I don't know. I know I am part. I do follow Nick. I like Nick. Let me see here. So I think they're back in court. So let's go back in here and see what we have in regards to if he got the line for the foreperson for the jury instructions. Shoot.
So everybody's present in the courtroom. The court has, sorry it's taking this long. We reconfigure the verdicts. We've now changed 484. I believe I've given the parties copies of that. There wasn't any mistakes on the, I say that now, but that were noticed at this point in time. If we're incorporating that into the jury instructions, we'll make the copies for the jury. That's going to take another 10 minutes or so. And these are the verdicts. It doesn't have to be the final verdict. Hopefully it's right because it's pretty much what's at 484.
I would note.
Where's the mistake?
The verdict offers an option to convict on second degree intentional.
Oh, yep, you're right. The 40. What the heck?
Yeah, my request with the verdict would be just like one single verdict form for each count: first degree reckless, second degree reckless, and then not guilty.
Oh, really? I thought you wanted them all in a row.
No, yeah.
I agree with how Attorney Zachary says. Having one form for each of as to guilty and then not guilty that covers all.
Yeah, I'm sorry if I wasn't clear on that. That was.
So you want one page, essentially?
One page each, yes.
Okay, that is a change. All right. What about count two? I hate to say it, but Christina had it that way, and I made her change it. She might not be happy with me on that one.
Blame it on me, Judge.
Sure, I usually do. Don't worry.
I think count two looks good.
I'm fine with that. I mean, if we want to keep consistency, we can break it back up again, but count two is as is.
Most verdicts, we do this.
Yeah.
We don't break it.
Yeah, I think it's fine in count two.
Yeah. And then count three. And there's 2 pages. Not guilty's on the second page.
Count three looks fine to me.
Okay. Let me go change count one. Yeah, thank you.
Judge, tell
Just realized it's completely wrong. I was changing it. I wonder what happened with
Judge?
It is right in the actual instructions.
Yeah.
So as y'all can see, they ate up whatever little TiVo time we had. So there we go. I tried to gain us some TiVo time with was watching the little thing and coming back, but of course, no. You know, they arguing about not guilty being on the second page. I knew we should. I should have probably went over to the Julio trial. At least they moving along. At least that's what Judge Cisco is doing. Judge Cisco running that courtroom, and she said, "Move this stuff along." Yeah, I don't even think it's the judge, Angela. I think it's the attorneys. Nah, it's just ugh. They going through. They didn't went through the jury instructions. They got the rebuttal witness on there. Mind you, they got 4 defendants to cross examine. And guess what? Judge Cisco, no matter how much we don't like her, she got that courtroom moving, baby. I don't even think they went on. Did they go on lunch yet? Let me see. Girl got this courtroom moving. Let me see. Yeah, I think they on lunch. They may be going to closing statements in a minute. I'm be over this trial here. Okay, they went to lunch. They'll be back at 1 o'clock, which is about 40 minutes from now. Yeah, Caleb Flynn, his trial is not gonna start until September, guys. So we got plenty of times to meet with him. I mean, he got his cry stuff down. That baby. He another Karina. Yeah, and I'm really interested to see, like, for our Julio trial, like how long it's gonna take a jury to come up with a verdict. I'm telling you, I would not be able to handle this. So they'll be back from Julio in a little bit. I don't know if they're gonna be doing closing statements when they come back. Let me see. Okay, so the state in the Julio trial, they do have another rebuttal witness that's gonna be appearing at 1 o'clock. Yeah, but with all this downtime this morning with this trial, man, this I should have went in the other trial. This one wasn't really worth going into this morning because they ain't did nothing. They ain't did nothing over here. But talk about some jury instructions. Hey, Mega, how are you? No, Claire, the witnesses, this is the in the Julio trial, we are in the state's rebuttal part, so it's kind of like doctors. Karina Cooper, she was accused, she was convicted of killing her husband with her boyfriend, her boo thing. But the strange part about it is that when the cops came in, she was
Seated. Here's, I forgot, these are count one modified without the not guilty, you're not guilty of that.
do this. Josie, run.
This is an extra. I don't know if you wanted that one. So lunch may not be till noon anyway. Yeah, that one I'll deal with it later. Okay. Yeah, actually, why don't we give her that extra copy? Here's the extra copy. Okay. All right, you ready to go on the record? Okay, all the parties are present. What you have in front of you is a copy of the jury instructions. The verdicts we changed to what we had just talked about. I don't know if the states had an opportunity to glance over it.
I did. I'm assuming you have the not guilty one and just gave us the.
Right, I just gave you the 3 guilties.
Yeah, that was my question as well.
Yeah, we have the 4 pages on the count one. We just didn't reprint that one. And then the other, so what the plan is right now is I'm going to read the instructions. We have lunch coming early. We'll probably have you come back. Depends on when I get done here, 12:30, 1:45, and then we'll do closings. Does that make sense? And I will also apologize for the court being slow this morning, but anything else from the state and defense?
Oh, yeah.
Bring the jury in. Oh, it took way too long. All right, everybody may be seated. Best laid plans. We thought we had this pretty well in hand, and then things didn't go right. It's my fault. Part of it is that we had a misunderstanding of certain things and we had a glitch. So I apologize for the late wait and the long wait. So I'll just to explain to you what we're going to do right now. So I'm going to do the jury instructions as the last part I read at the very end after closings. Do the jury instructions, have you eat lunch, and then we'll probably bring you back hopefully a little bit early. Then we do closings. There is a limit on the closings, so it won't go for 2 days or 3 days. It's going to go for a few hours though, to give everybody an opportunity to say what needs to be said. So having done that, let's start with the jury instructions. As you can see, it's very long. You will get copies of this for the jury room when you're deliberating too. But let's start with these instructions. Members of the jury, the court will now instruct you on the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the cases which have in the case which have been properly proven by the evidence. Consider only the evidence received during the trial. The law as I give given to you by these instructions and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of the information in this case charges that count 1, first-degree intentional homicide, first-degree reckless homicide, second-degree reckless homicide, in section 940.01, parent 1, parent A, 940.02, parent 1, in the Wisconsin in 10.18. Josie Dikeman, on or about Saturday, February 11th, 2023, at County Road OS in the town of Madera, La Crosse County, Wisconsin, did cause the death of Xavier Pedrin, date of birth 7/10/2016, with intent to kill that person or another, contrary to 940.01, parent 1, parent A, with stats. To this charge, Josie Dikeman has entered the plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Crimes to consider. The information charges Josie Dikeman with first-degree intentional homicide. You must first consider whether Josie Dikeman is guilty of that offense. If you're not so satisfied with that Josie Dikeman is guilty of first-degree intentional homicide, you must consider whether or not Josie Dikeman is guilty of first-degree reckless homicide or second-degree reckless homicide, which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crime referred to as first-degree intentional, first-degree reckless, and second-degree reckless homicide are different types of homicide. Homicide is the taking of life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that Josie Dikeman caused the death of Xavier Pedrin. First-degree intentional homicide requires that the state to prove that Josie Dikeman acted with intent to kill. First-degree reckless homicide and second-degree reckless homicide require that Josie Dikeman acted recklessly. First-degree reckless homicide required proof of one additional element, that the circumstances of the Josie Dikeman's conduct showed utter disregard for human life. It is for you to decide what type of homicide Josie Dikeman is guilty, if guilty at all, according to the instructions which define the two offenses. Statutory definition of first-degree intentional homicide. First-degree intentional homicide is defined in Stats 940.01 is committed by one who causes the death of another human being and with intent to kill that person or another. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Elements of first-degree intentional homicide the state must prove. 1, Josie Dikeman caused the death of Xavier Pedrin. Cause means that Josie Dikeman's act was a substantial factor in producing the death. 2, Josie Dikeman acted with intent to kill Xavier Pedrin. Intent to kill means that Josie Dikeman had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that Josie Dikeman acted with intent to kill, it does not require that the intent existed for a particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into Josie Dikeman's mind to find intent. Intent to kill must be found, if found at all, from Josie Dikeman's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in the establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedrin with the intent to kill, you should find Josie Dikeman guilty of first-degree intentional homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree intentional homicide, and you should consider whether Josie Dikeman is guilty of first-degree reckless homicide in violation of Stat 940.02, Parent 1, which is a lesser included offense of first-degree intentional homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Josie Dikeman is guilty of first-degree reckless homicide. Statutory definition of first-degree reckless homicide. First-degree reckless homicide is defined in Wisconsin Statute 940.02, Parent 1, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Elements of first-degree reckless homicide the state must prove. 1, Josie Dikeman caused the death of Alexavier Pedrin. Cause means that Josie Dikeman's act was the substantial factor in producing the death. 2, Josie Dikeman caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created to a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that her conduct created the unreasonable and substantial risk of death or great bodily harm. 3, the circumstances of Josie Dikeman's conduct show utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Josie Dikeman was doing, why Josie Dikeman was engaged in the conduct, how dangerous was the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also Josie Dikeman's conduct after death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time of the death occurred. Jury's decision. You are satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedrin by criminal reckless conduct, and that circumstances of the conduct showed utter disregard for human life. You should find Josie Dikeman guilty of first-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree reckless homicide, and you should consider whether Josie Dikeman is guilty of second-degree reckless homicide in violation of Wisconsin Statute 940.06, which is a lesser included offense of first-degree reckless homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Statutory definition of second-degree reckless homicide. Second-degree reckless homicide is defined under Wisconsin Statute 940.06, is committed by one who recklessly causes the death of another human being. Difference between first and second-degree reckless homicide. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstance of Josie Dikeman's conduct showed utter disregard for human life. Jury decision. If you're satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstance of the conduct showed utter disregard for human life, you should find Josie Dikeman guilty of second-degree reckless homicide. In other words, if you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexander Pedrin by criminally reckless conduct, you should find Josie Dikeman guilty of second-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty. You are, in any event, to find Josie Dikeman guilty of one or more offense as to count one. Just so I'm going to just repeat that. You are not, in any event, to find Josie Dikeman guilty of one or more offense as to count one. Count two, chronic neglect of child consequence is death. Josie Dikeman, between January 1st, 2021 and February 11th, 2023, at County Road OS in the town of Madera, La Crosse County, Wisconsin, being a person responsible for the welfare of a child, Alexander Pedrin, through her action or failure to take action for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered death as a consequence, and the actor is guilty of chronic neglect as she committed 3 or more violations under 948.21 parent 2, with a specific period of time involving the same child, to wit, Alexander Pedrin, contrary to 948.215 parent 1 and parent 2, parent A, Wisconsin statutes. To this charge, Josie Dikeman has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Statutory definition of the crime. Section 948.215 of the Criminal Code of Wisconsin is violated by one who commits 3 or more violations of Section 948.21 parent 2 within a specific period of time involving the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. Elements of the crime that the state must prove. 1, Josie Dikeman committed 3 or more violations of Section 948.21 parent 2 involving Alexander Pedrin. Section 948.21 parent 2 of the Criminal Code of Wisconsin is violated by any person who is responsible for the child's welfare who, through action or failure to take action for reasons other than poverty, negligently fails to provide any of the following so as to seriously endanger the physical, mental, or emotional health of the child, necessary care, necessary food, necessary medical care, education and compliance with Section 118.15 or to drug abuse as defined on 46.973 parent 1 parent B. Elements of Section 948.21 involving the same child. A, Alexander Pedrin had not obtained the age of 18. Knowledge of Alexander Pedrin's age is not required, and mistake regarding Alexander Pedrin's age is not a defense. B, Josie Dikeman was a person responsible for the welfare of Alexander Pedrin. A person responsible for the welfare of a child includes a person who is employed or used by one legally responsible for the child's welfare to exercise temporary control or care of the child. B, Josie Dikeman, through action or failure to take action, and for reasons other than poverty, failed to provide the necessary care, necessary food, necessary medical care, education and compliance with Section 118.15, or to drug abuse as defined under Section 46.973 parent 1 parent B. Section 118.15 of the Wisconsin statute is violated by a person who has under her control a child between the age of 6 and 18 years and fails to cause the child to attend school regularly during the full period and hours that the school is in session until the end of the school term, quarter, or semester of the school year in which the child becomes 18 years of age. Section 46.973, parent 1, parent B, the Wisconsin statute states, drug abuse means the use of drug in such manner as to endanger the public health, safety, or welfare. D, failure to provide seriously endanger the physical, mental, or emotional health of the child. To seriously endanger means to create a serious risk of harm or injury. E, the failure to provide was negligent. Negligent means acting or failing to act in such a way that a reasonable person would know or should know seriously endangers the physical, mental, or emotional health of a child. Element 2, at least 3 violations of neglect as previously defined involving Alexavier Pedrin took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman, you must unanimously agree that at least 3 violations of Section 948.21 involving the same child occurred between January 1st, 2021 and February 11th, 2023, but you need not agree on which acts constitute the required 3. Element 3, Alexavier Pedrin suffered death as a consequence. Jury's decision. If you're satisfied beyond a reasonable doubt that all 3 elements of this offense have been proved, you should find Josie Dikeman guilty. If you're not so satisfied, you must find Josie Dikeman not guilty. The third count of the information in this case charges that count 3, physical abuse of a child, repeated acts causing death, 948.03, parent 5. Josie Dikeman between January 1st, 2021 and February 11th, 2023 at County OS in the town of Madera, La Crosse County, Wisconsin, did commit repeated acts of physical abuse involving Alexavier Pedrin, where at least 3 of the acts were violation of 948.03, parent 2 Wisconsin statutes. And at least 1 violation caused the death of Alexavier Pedrin, contrary to 948.03, parent 5, parent A, 1 Wisconsin statutes. Statutory definition of crime. Just a second. Section 948.03, parent 5 of the Criminal Code of Wisconsin is violated by one who, within a specific period of time, commits 3 or more acts of physical abuse of a child, of the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. Elements of the crime the state must prove. 1, Josie Dikeman committed at least 3 acts of physical abuse of Alexavier Pedrin. In this case, Josie Dikeman is alleged to have committed physical abuse of a child by violating Section 948.03, parent 2, parent B. Physical abuse of a child is defined by 948.03, parent 2, parent B of the Criminal Code of Wisconsin is committed by one who intentionally causes bodily harm to a child. Before you may find Josie Dikeman guilty of committing an act of physical abuse of a child, the state must prove by evidence which satisfies you beyond a reasonable doubt the following 3 elements were present to establish an act of physical abuse of a child. A, Josie Dikeman caused bodily harm to Alexavier Pedrin. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. B, Josie Dikeman intentionally caused bodily harm. This requires that Josie Dikeman had the mental purpose to cause bodily harm to Alexavier Pedrin, or was aware that her conduct was practically certain to cause that result. C, Alexavier Pedrin had not obtained the age of 18 at the time of the offense. Knowledge of Alexavier Pedrin's age is not required, and mistake regarding Alexavier Pedrin's age is not a defense. Element 2, at least 3 acts of physical abuse took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman guilty, you must unanimously agree that at least 3 acts of physical abuse occur between January 1st, 2021 and February 11th, 2023. But you need not agree on which acts constitute the required 3. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman committed 3 violations in 948.03 parent 2 parent B within the specific period of time, you should find Josie Dikeman guilty. If you find Josie Dikeman guilty, you must answer the following question. Did at least one violation cause the death of Alexander Pedrin? You must all agree on the violation that caused death. If you're not so satisfied, you must find Josie Dikeman not guilty. If you cannot agree on the violation that caused death, you should consider the following question. Did at least one violation result in great bodily harm to Alexander Pedrin? Great bodily harm means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss of or impairment of the function of any body member or organ or other serious bodily injury. If you cannot agree on the violation that caused death, you should consider whether a violation resulted in great bodily harm. To answer yes, you must agree on the violation that caused the great bodily harm. In reaching your verdict, examine the evidence with care and caution, act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. The presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt the defendant is guilty. State's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from the fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt which, such as that may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of any reasonable doubt that remains after carefully considering all the evidence. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both in direct and cross-examination, regardless of who called the witnesses. Second, the exhibits the court has received, whether or not the exhibits go to the jury room. Third, any facts which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside of the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. In fact, a fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed an offense before you may find the defendant guilty. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Evidence presented for Josie Dikeman. Evidence has been presented regarding the conduct of Josie Dikeman for which she is not on trial. You may consider the evidence only for the limited purpose and not to conclude that Josie Dikeman has a bad character or a general tendency to commit crimes. You must not use this evidence to decide that because Josie Dikeman allegedly committed another act at some other time, Josie Dikeman must have committed the offense now charged. Specifically, evidence has been presented that Josie Dikeman was involved in prior incidents in 2011 and 2013. If you find that conduct did occur, you should consider it only on the issue of identity. You may not consider this evidence to conclude that Josie Dikeman has a certain character or a certain character trait that Josie Dikeman acted in conformity with that trait or character with respect to the offense charged in this case. Definition for Josie Dikeman. The evidence was received on the issue of identity. Is the prior conduct of Josie Dikeman so similar to the offense charged that it tends to identify Josie Dikeman as the one who committed the offense charged? Evidence presented for Derek Pedron. Evidence was presented regarding conduct of Derek Pedron, specifically that Derek Pedron was physically abusive to Josie Dikeman, Alexander Pedron, and other children in the home, and that Derek Pedron purchased and used alprazolam Xanax. If you find this conduct has occurred, you should consider it only to the issue of motive, opportunity, intent, identity, context, and source of injuries. You may not consider the evidence to conclude that Derek Pedron has a certain character or a certain character trait, and that Derek Pedron acted in conformity with the trait or character. Definitions for Derek Pedron. The evidence was received on the issue of motive, that is, whether Derek Pedron has a reason to desire the result of the conduct alleged. Opportunity, that is, whether Mr. Pedron had opportunity to commit the conduct alleged. Intent, that is, whether Mr. Pedron acted with a state of mind that is required for the conduct alleged. Identity, that is, whether the prior conduct of Mr. Pedron is so similar to the conduct alleged that it tends to identify Mr. Pedron as the one who committed the conduct alleged. Context or background, that is, to provide more complete presentation of the evidence relating to the conduct alleged. Propensity-free reasoning requirement. To use this evidence properly, your reasoning must be propensity-free. That you must not reason in this way. Because Josie Dikeman committed another act or crime, she probably acted in the same way again. That kind of reasoning is forbidden. If you cannot follow this propensity line of reasoning, you must disregard the other acts and evidence entirely. You may consider the evidence only for the purpose I have described, giving it the weight you determine it deserves. Is not to be used to conclude that Josie Dikeman is a bad person and for that reason is guilty of the offense charged. Remarks of the attorneys are not evidence. The remarks suggested certain facts not in evidence, disregard the suggestion. Attorneys for each side have the right and the duty to object to what they consider are proper questions asked of witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received or the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witness and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggests that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony be stricken. Disregard all stricken testimony. You have heard and viewed an audiovisual recording. Recordings are proper evidence, and you may consider them just as any other evidence. You may consider the actions of a person, facial expressions, and lip movements that you can observe on videotapes to help you to determine what was actually said and who said it. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters for your common knowledge and your observation and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight you give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts which upon it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find the facts stated in the hypothetical questions have not been proved, then the opinion based on those facts should not be given any weight. It is the duty of the jury to scrutinize and weigh the testimony of witnesses and to determine the effect of evidence as a whole. You are the sole judges of the credibility, that is, the believability of witnesses, and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other physical characteristic. Determine the credibility of each witness and weight you give to the testimony of each witness. Consider these factors. Whether the witness's interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matter the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit testimony. Then give to the testimony of each witness the weight you believe it should receive. Josie Dikeman has testified in this case. You should not discredit the testimony just because Josie Dikeman is charged with a crime. Use the same factors to determine the credibility and weight of Josie Dikeman's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. Should do the same thing here. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It is not to be used for any other purpose. Evidence has been received that Josie Dikeman had been convicted of a crime. This evidence has been received solely because it bears upon Josie Dikeman's character for truthfulness as a witness. It must not be used for any other purpose. And particularly, you should bear in mind the criminal conviction at some previous point, let me say that again, at some previous time is not proof of guilt of the offense now charged. The testimony of child should be weighed in the same manner as testimony of any other witness. considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and the answer them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters bearing on the credibility applied to a child witness in common with all other witnesses. Now, the next two parts I will read when we get to the closing arguments. Because of the timing of this, what we're going to do is we'll take a break right now, have you have lunch. I would like to start at a quarter to one, so it gives you a little less than an hour, so we can get to the closing arguments. Please still don't talk about the case, even though I'm halfway through the jury instructions. But we'll have lunch and we'll have you come back and we'll go from there. See you then. Can you leave those here for right now? Yeah, leave them here. Thank you for asking. All right, everybody being seated. Is there any problem with the way I read the instructions so far? Defense?
All right.
There was one word I changed, by the way. There was a "the" that was sort of misplaced, but it was pretty minor. So be back at, let's say, 22, so we can start right up at quarter to.
You're good.
Thank you.
Okay. So I have a question, y'all. Because we like running neck to neck with these trials today. I think I want to go ahead and start the Folio coverage. I mean, so we don't have this downtime during lunch. They kind of like in the same boat, like they running neck to neck, but at least with the Folio trial, it is like moving along like it should be. Far as instructions and different stuff like that. So they did have a rebuttal witness that they put on this morning. So we'll kind of like do a flip-flop. Then that way I can make a new thing for closing statements. I'll make a new alert to go out for closing statements and stuff. Let me get this over here. I will get the link for the new room for everybody. I will make it where when this ends, it should take us right over to the Folio room. Give me 1 second. Let me see if I can put a redirect in here. And then this way it seems like we're gonna be in verdict watch for both of them around the same time, which is fine for me. And yeah, because we don't have any TiVo time or anything, and the judge is long-winded and blah 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 blah. Okay, so just in case anybody gets lost when I end the stream, here is the room for the Folio trial. They in there. I accidentally got the Folio trial scheduled for 10 o'clock p.m. I had it scheduled for like 10 o'clock tonight, y'all. Didn't nobody say nothing. Tanya and them over there, and they ain't said nothing. I did not know. I didn't know that. I see Tanya in there like, that's late. What? I was not trying to do it at 10 o'clock at night. My bad. Did nobody say anything to me? But okay. All right, guys. I will see you guys over there.